Good morning, good afternoon, everyone. I am Elizabeth Limbrick with the New Jersey Institute of Technology's Technical Assistance to Brownfields program. I will be your moderator for today's webinar. In addition, my colleague Sean Broom will be your host, and we also have Bob Blauvelt on our team to present the subject matter today. This webinar is developed and produced by NJIT's Technical Assistance to Brownfields program, which is funded by the US EPA. First, I'm going to take you through course outline. We're going to talk about the logistics. I'm going to give you a very brief overview of the NJIT TAB program. We're going to talk about the ASTM Phase 1 changes, the US EPA and how they're integrating the new ASTM Phase 1 standard. We're going to talk about recognized environmental conditions and controlled recognized environmental conditions, also known as CREC. Then we'll have an opportunity for a question and answer break. We'll get back into the subject matter. We'll talk about definitions and clarifications, including what is reasonably ascertainable data and the new user responsibilities and requirements for a regulatory agency file review and records review. Finally, at the end, we will have a Q&A wrap-up. And in addition to Bob Blauvelt, we are also pleased to have Tricia Overmeyer from EPA headquarters who is attending this webinar as well. And she will be available to answer your questions about all appropriate inquiries. Like I mentioned, we have a few logistics to go over first. We are putting all of the participants on mute to minimize the background noise. At the top of your screen, you'll see a green tab which contains your controls. You can use your control tab to open a chat window. Please type your questions in the chat window and send them to me, Elizabeth Limbrick, the moderator. Once you type in your questions, they will come to me. During the question and answer break, I will ask your questions, and then the presenter will respond. We are scheduled for 1 hour, but we will keep the web room open at the end of the hour to answer the questions. This webinar will be recorded and posted to our website at njit.edu/tab. If you do experience technical difficulties, please use that chat function or call our hotline at 973-642-4165. Many of you are familiar with the NJIT TAB program. But anytime we do a workshop or a webinar, we reach a new audience, and we want to make sure that you know a little bit about who we are and how to get more information on us. So first of all, TAB is a technical assistance program that's funded by the US EPA. We are intended to serve as an independent resource to communities and nonprofits attempting to clean up and reclaim brownfields. The NJIT TAB program covers EPA regions 1 and 3, so that's New England and the Mid-Atlantic. If you're in one of the other regions, you can visit the EPA website to find out who your TAB provider is. So who can receive NJIT TAB assistance? And we have it listed right here. So it's communities, regional entities, state entities, government entities, that is, and nonprofits interested in brownfields. What are these services? Well, they are free to eligible entities, absolutely positively free. That is because we have a grant from EPA that provides for us to provide these services to you, the eligible entity. Again, that's going to be a government or a nonprofit entity. And they're really throughout the brownfield process, from getting started to staying on track to getting the job done. We have a really wide range of tools available to us, and a lot of times we like to say it's easier to say what we don't do rather than what we do. We're not your environmental consultant. We do not collect samples. We do not analyze samples, and we do not write grant proposals. But beyond that, really, we have a lot of flexibility and a lot of tools available to us to provide a broad spectrum of services. And on the next slide, I'm going to give you some more info on that. But all of those services must be aimed at achieving brownfield cleanup and development and be consistent with Region 1 and Region 3 programs. So some examples of NJIT TAB services. First of all, there's the direct technical mentoring. And we can do that through meetings or phone calls or email. And that's where we work directly with the community and we provide services. And for example, types of services we've provided in the past are visioning charrettes. We've helped community develop strategies to prioritize their brownfield site redevelopment. We've done reuse planning. And we've even provided guidance on specific technical issues. For instance, if you go to our website, you'll see we have a series of brochures to guide you through PCB rules under TOXA. In addition to that, we also provide another service that we call Review, Analysis, and Interpretation of Technical Reports. And an example of that is that we've worked with the Environmental Justice League in Rhode Island. And in that particular case, they have a site that is owned by a utility company, and it's also a former manufactured gas plant. And they have concerns because there are schools and just residents that live adjacent to that site, and so they're concerned about how the contamination is impacting that community. They pass on the reports from the consultant to the Rhode Island DEM. They give those to us, we take a look at them, and then we interpret them and put them in plain language for the community. And then we also provide recommendations on the remedial approaches as well as how to safeguard the community. So that's an example of that. As you can see here, we also provide other assistance such as assistance with procuring consultants. We do examples of RFPs. If you ask us to, we can sit on your consultant selection committee. In addition, we've done lots of collective community workshops from brownfield basics to specific issues. For instance, again, reuse planning, revolving loan funds. We did a series of workshops on mill redevelopments as well. So if there are workshops that you're interested in, get back to us, let us know so that we can develop specific workshops that will be of interest to you in the future. Same thing with webinars. We have a series of webinars that are archived on our website, and they include how to prepare for applying for an EPA brownfield grant, how to actually apply for an EPA brownfield grant and be competitive. We have them on funding for brownfield projects, and we've also done community engagement. And then, of course, there's today's webinar on the ASTM Phase 1 changes in all appropriate inquiry. So with that, I want to provide you with our contact information so that if you are an eligible entity, and again, that's going to be a government or nonprofit community organization in EPA Region 1 or Region 3, please get in touch with us. Our hotline is 973-642-4165. And we have a dedicated email address as well, tab@njit.edu. And that's all it takes for us to start the free assistance. So again, if you're an eligible entity, contact us. If you know someone who is and could use our services, please let them know about us. With that, I'd like to introduce our presenter, Bob Blauvelt. He is part of the NJIT TAB team. He is with GEI Consultants. He's a geologist with more than 25 years of experience. He was an active participant on the ASTM Subcommittee E50.02, which prepared the revised 1527 AAI standards. Over the course of his career, he's done hundreds of Phase 1s. He holds environmental licenses in New Jersey, Connecticut, and Massachusetts. And he has a bachelor's and master's degree in geology from Rutgers University. And I just want to reiterate, I don't know if I mentioned it previously, we also do have Patricia Overmeyer as from EPA headquarters, who's on the call, and she can take questions if you have questions about AAI. She is the one who coordinated the development of the All Appropriate Inquiries rule. With that, I'm going to turn this over to Bob Blauvelt.
Thank you, Elizabeth, and thank all of you for joining us today on the webinar this late morning, early afternoon from New Jersey's premier technology institute, NJIT. My 15 or so PowerPoints that I'll be discussing during the next hour are divided into three main categories or topics. First, I'll go through a brief history of AAI and ASTM 1527 and how EPA is approaching the integration of the new standard into 40 CFR Part 312. Next, I'll walk us through two or three of the main revisions to 1527.13, those dealing primarily with RECs, recognized environmental conditions, whose identification and classification are really at the heart or core of the AAI process. Finally, we'll wrap up with some definitions and clarifications that I think are important to note in the 13 standard. As Elizabeth indicated, we have a couple of places during the webinar where we invite comments and where you can ask questions. I am interested in everyone's feedback and find important information or concepts are often brought up during the Q&A sessions, and I look forward to discussing what we may uncover during those breaks. I do want to note that this webinar assumes a reasonable working knowledge of ASTM 1527 and the environmental due diligence process. It is not designed or intended to be a primer on how to do a phase one, but rather to point out the differences between the new and the old standards, which I'll refer to during the discussion as 05 and 13, and as well to alert the user and the environmental professional as to the significance of those changes. I did my first phase one, although it wasn't called that, in 1983 at an old industrial property in Paterson, New Jersey. And it was a seat of the pants process. We thought we knew what the client was looking to accomplish, essentially identifying environmental issues, or we didn't use the word liabilities at the time, but in identifying environmental concerns, if you will, on the property, and then trying to figure out how much that all would cost to fix. I think we accomplished those goals, but to this day, I am glad that transaction never went forward on the advice we'd given the client. During the late 1980s and early 1990s, the need for environmental assessments continued to pick up steam, being driven largely by the joint and several liability provisions of CERCLA, which had passed a few years earlier. And with CERCLA came a developing awareness by buyers, lenders, and insurers that they needed to consider environmental conditions at a site before acquiring. In 1986 SARA, the Superfund Amendments and Reauthorization Act, codified the concept of innocent owner, but required, and here in air quotes, acquisition without knowledge, end of air quote. In other words, the purchaser must have undertaken all appropriate inquiry into the previous ownership and the use of the property in a manner that was consistent with, again, another set of air quotes, good commercial or customary practice. The only problem was that in 1986, there was no reliable definition of what good commercial or customary practice was. There were numerous protocols and procedures being used for environmental due diligence, including those published by the National Groundwater Association, the Geological Society of America, various banks and lending institutions, as well as several private environmental certifying organizations. To address this issue, this problem really, in 1989, ASTM organized the E50.02 subcommittee on commercial real estate to prepare a standard for AAI. It took 4 years of fairly intense effort by over 100 subcommittee members, but ASTM 1527-93 eventually was published. 93 being 1993. 93 was quickly adapted as the benchmark for environmental due diligence, perhaps largely because of the wide variety of stakeholders that had participated in its development, as well as the flexibility of its language. The 93 standard would be revised by ASTM in 1997 and again in 2000. In 2002, the federal Small Business Liability Reef and Brownfield Revitalization Law, the Brownfield Law, the Brownfield Act, went into effect. This statute established additional CERCLA liability relief provisions in addition to the innocent owner, the bona fide prospective purchaser, and the contiguous property owner, and while citing the 2000 standard, 1527-2000, as an interim way to demonstrate AAI, the law also directed EPA to develop its own standards and practices for environmental liability protection. It took 4 years, but working closely with the E50 subcommittee, EPA issued a final rule in 2006 adopting a modified 1527 standard, now called 1527-05, as being consistent with the SARA AAA criteria. However, as the environmental due diligence market matured, and as I'm sure we've all experienced, the quality of phase 1 reports often varied widely. From very good to less than adequate. Excuse me, just one second. Yeah. Sorry. From very good to less than adequate. Pricing pressures and schedule constraints on both users and environmental professionals often led to phase 1 reports that fall short of the AAI performance objective of acquisition without knowledge. In 2011, EPA's Inspector General reviewed 35 phase 1 reports filed under the Brownfield program and found none of them consistent with AAI requirements, although many were cited for non-compliance based on administrative or formatting issues as opposed to missing information or misclassifying recs. The IG's report raised important questions of whether human health and the environment have been placed at risk at brownfield sites because of inadequate or non-compliant phase 1 assessments. My own feeling is probably not. That if environmental issues are discovered during redevelopment, they are going to be addressed. Owners, lenders, builders have become highly sensitized to the long-term consequences on the value or marketability of a property where questions regarding environmental quality or human health remain unanswered or unresolved. More importantly, though, does the failure of a phase 1 report not to strictly follow 1527 open the door for the loss of CERCLA liability protections? That is a trickier question that perhaps some of you have had direct experience with, and we can talk about during the Q&A session. Clearly, if and when 1527 non-compliance becomes an issue, either before or after a transaction, at the very least, the environmental professional who prepared the report, who prepared the phase 1, is going to have some uncomfortable moments explaining why his or her report varied from the standard. It is a business necessity and has been for some time, not only for brownfield grantees, but also for most purchasers of commercial or industrial property, to assess potential environmental liabilities on a target site. The marketplace has absolutely embraced 1527 as the standard to follow, and after some appropriate cautious deliberations, EPA is following suit. On December 30th, 2013, EPA published its AAA final rule, unequivocally stating that the use of ASTM 1527.05 or 1527.13 or the requirements of the final rule itself as suitable for demonstrating compliance with AAI's due diligence obligations. There is a link on the slide that takes you to a pretty useful document that summarizes EPA's findings and provides a short checklist for brownfield grant applicants to help ensure Phase 1 AAI compliance. It is my understanding that EPA is pursuing additional rulemaking to omit the 1527.05 reference, but that is further away. Again, the marketplace has already decided, and I cannot imagine a circumstance, contractual or not, where a competent environmental professional would seek to prepare a Phase 1 report using the 05 standard. I do want to caution you that some states may require additional activities other than just an AAI compliant Phase 1 in order to obtain liability relief. Here in New Jersey, for example, to obtain release from state Spill Act liability, a preliminary assessment, or PA, also needs to be prepared that addresses some additional requirements described in our own administrative codes, NJIT 726E. Other states may have similar obligations, and if you are aware of such requirements, please send us a note through the webinar system so we can share that with the entire audience during the Q&A session. At this point, I'd like to mention that the 1527.13 revisions are just that, revisions. The stakeholders on the subcommittee felt, in general, the standard was working well, and there was no strong consensus to conduct a major overhaul of the process. So, as we get into the changes that were enacted, be aware that we were really focused on clarifying some definitions and procedures, providing the environmental professional with the ability to exercise more professional judgment during the course of the Phase 1, and tightening the need to ensure that users understood long-term obligations that may be associated with institutional and engineering controls that are now much more common and in place than they were in 2005. Well, we'll spend just a minute here on the revision process itself, and I want to mention that what really helped make the 13 updates so successful was the subcommittee chairperson, Julie Kilgore of Wasatch Environmental, just a strong and dynamic leader throughout the revisions, who went out of her way to ensure that all opinions and comments, sometimes no matter how trivial and self-serving they seem to be, were heard and evaluated fairly. About 75 people were on the committee that represented lenders, users, attorneys, suppliers, and consultants. EPA was an active observer during the process, along with a few other state regulatory agency representatives. Each component of the standard was assigned to various subcommittees with proposed revisions compiled into a single document, which, after vetting by Julie and a few of her key advisors, were then distributed for review and consideration by the entire subcommittee. ASTM, if you don't realize it, is a very consensus-driven organization, and 60% of the subcommittee has to vote, and 2/3 of those votes have to be positive, have to agree with the changes for the revised standard to move forward for overall approval and publication by ASTM. ASTM staff, full-time staff at the organization, oversaw the balloting process, And if there were objectives, which are called negatives, those either had to be addressed in some way. They either had to be worked through the subcommittee or as part of discussions and perhaps revisions to the proposed changes. They had to be withdrawn, or in a final step, they had to be dismissed as non-persuasive. That is a big deal to get that through the ASTM process. So again, the intent is to address everyone's concerns and not to try to just dismiss as non-persuasive issues raised by subcommittee members. The ballot closed in October 2012, and it took to November 6, 2013, almost a full year, to work through the final negative and publish the new standard. So with this context of how the 13 standard came into being, let's get into some of the more significant changes. I apologize for the next few slides. They are text heavy, but I did want to illustrate the old versus new because the distinctions are meaningful. Also, you will see several references in the next few slides to report findings versus report conclusions. If you could bear with me for a few minutes, I'll explain on a separate slide what those distinctions mean and why they are important. So here on this slide, I wanted to illustrate that one of the more significant changes to 13 is the definition of a REC, of a recognized environmental condition. The new, more simplified REC definition on the right is intended to provide flexibility to the EP to broadly identify releases or potential releases to the environment. Note that the old definition talked about structures and groundwater or surface water. Those terms have been replaced with a more comprehensive environment. Also, language that forced the EP, the environmental professional, to make a determination as to whether the release was or was not in compliance with laws, and you'll see it here on the left, quoted as even under conditions in compliance with laws, has been removed. The intent of the new text is to allow the EP to more easily determine whether a release has occurred and then classify this release as to the type of REC, as to the type of recognized environmental condition it might be, historic or controlled, and we'll talk about that in a minute, and therefore whether additional action may be necessary. So HRECs, historic recognized environmental conditions, shown on this slide, are an important tool in describing current conditions on a site that are related to past environmental compliance actions. The 13 definition, which is slightly modified here just for convenience so I can fit it on the slide, and I refer you to the standard for the full definition, but is the intent of the 13 HREC definition is to provide the EP with guidance that states if the regulatory agency, or in the case of states where cleanups are overseen by licensed individuals, such as Massachusetts, agree that unrestricted use standards have been met, then the release can be classified as an HREC, as an historic recognized environmental condition, and no further action is likely necessary. So again, emphasizing the new HREC definition, if you've got a release, a past release, and the site currently meets all unrestricted use requirements, if there is no continuing obligation at the facility or at the associated with the release, then this issue can, this concern can be called an HREC. However, if a regulatory agency standards have changed since the previous unrestricted use determination has been made. So if those standards change, and the site no longer qualifies or meets unrestricted use criteria, then the release cannot be called an HREC, but needs to be called a REC, a full-blown REC, that again may require further action. So the HREC term, unless this distinction is made, can be used inappropriately. Let me walk you through an example here that's a little tricky to follow, but it can be used incorrectly when referring to a release from a former or prior activity that still is present on the site. And for example, if we take a facility or a piece of property that was a gas station where there were some groundwater impacts, and those groundwater impacts are still being evaluated or remediated, but the facility is now a donut shop. Again, and the groundwater problem is still present as a result of prior station activities. If the groundwater impacts had been remediated and regulatory closure achieved, and the site not subject to further controls, then that's an HREC. However, in our example, because the groundwater impacts are still under investigation or remediation, then it is a REC, even though the activity that caused that release has long gone away. The gas station is long closed. It's now selling donuts instead of gas. Although the groundwater impacts are still there, that is a REC. It exceeds a regulatory standard. It has not met unrestricted use criteria. That is still a REC. Simply put, HRECs are those releases that have been closed out by the appropriate authority to an unrestricted use standard or guideline and do not require any further remediation or institutional or engineering controls. We'll talk more about the difference between RECs and HRECs when we go over an example a little more formally in a few minutes. Controlled RECs, controlled recognized environmental conditions, is a new term introduced in the 13 revision and one of the more important changes. It recognizes that not all sites are cleaned up to unrestricted use standards, and importantly, that there may be certain long-term monitoring and maintenance obligations associated with staying in compliance with regulatory closure responsibilities. So, if a site has been issued a closure approval by a regulatory authority, but has an obligation to maintain an engineering control, say an asphalt parking lot to limit access to contaminated soil or impacted soil, or a subslab venting system that needs to continue to operate to control the intrusion of vapors into the structure, then this obligation would be identified as a CREC, a controlled recognized environmental condition. The subcommittee felt it important during the revision process in developing this category of REC to make sure the user knew that even though regulatory approval had been obtained for a REC, even though regulatory closure had been obtained, there was still a long-term obligation requiring compliance. De minimis conditions are the one area that most often tests the professional judgment of the environmental professional. None of the terms used in the 13 standard for de minimis are defined, and the wording allows for significant leeway in deciding whether to call a problematic condition on a property de minimis or not. This may also be client-specific, with some users opting for a very conservative approach, that is calling anything potentially problematic on a site a REC. For example, I've worked with clients that have had us include oil stains from cars on the asphalt parking lot as a REC. Other users, other clients may take a more aggressive approach and insist on having a more definitive indications of an environmental release or impact before considering an observation or a concern identified on the property as a wreck. The picture on this slide is an example taken at one of my sites. I struggled as to whether or not to classify this as a wreck. Although the building inspector, a regulatory authority, would probably cite this as some type of violation. Has a release to the environment really occurred, or is this more of a housekeeping issue? Frankly, when this was pointed out to the owner of the property, he was embarrassed. He sent me a picture a few days later of the area, which had been cleaned up. And at the end of the day, in consultation with the client, I elected not to call this a wreck. But I did describe in the Phase 1 report what I saw and included both the before and after pictures. While we're on the subject of reports, I did want to take a moment to point out that although this hasn't changed, the 05 and 13 descriptions of report findings and report conclusions remain the same. I think it's important to note the distinction here. The findings in a Phase 1 report include all conditions that were evaluated during the process, even those that were dismissed from further consideration. The hydraulic fluid tank in the elevator control room, or the locked chemical storage cabinet near the loading dock, those get described in the report findings and the reason for not carrying them further through the process provided. The findings section should give an overview of the scope of the evaluation and provide a brief explanation of why observations were either dismissed or identified as a wreck. The conclusion section summarizes the wrecks, including C-wrecks, and describes the basis for their identification, for their listing, if you will. Note that it does not include H-wrecks or de minimis conditions. Those are dismissed or described and not carried forward in the findings sections. Those are only described in the findings section. I did want to mention that there was a fairly spirited discussion during the revision process as to whether or not to require recommendations as part of the Phase 1 report. Many stakeholders pressed for recommendation exclusion and suggested that they are better placed in a cover letter that is attached to the Phase 1 report. I know company policies differ in this regard among environmental professionals, and I'd be interested in hearing how you are managing presentation and inclusion of recommendations as part of the Phase 1. Are they in the reports? Are they provided in a cover letter, or are they transmitted, if at all, as some other way? So if you have a moment, again, drop us a note through the webinar system, and we'll try to summarize and compile those results. So let's take a moment and walk through a simple example of an H-wreck and a C-wreck. And I'll give you a moment here to read through this. Okay. The key fact in the description of this site is that the property was remediated to a non-residential standard. In other words, it was not an unrestricted use cleanup. Under 05, this would have qualified as an HREC. But under 13, because of the institutional control requirement, let's assume some sort of deed notice or activity and use limitations in place, it now needs to be shown as a CREC. And included in the findings section and conclusion section of the Phase 1 report. So again, because this has an obligation, a long-term obligation, it has an institutional control, we cannot dismiss it as an HREC. It's now included as a CREC and needs to be carried through the process, both the findings and the conclusion section of the Phase 1 report. What recommendations might typically be associated with a CREC? Again, be interested in hearing about those, drop us a note through the webinar system. So, on to example number 2, and again, I'll give you a minute to read that. Okay, here, the key fact is that the water quality standards changed after the unrestricted use was approved. So the owner, I'm sure, is no doubt waiving his unrestricted use, no further action letter at the EP and showing it, emailing it to anyone who will take it, saying that the site is closed. Even though, under the old standards, the last round of water quality samples collected in 2004 does not meet the 2012 regulatory agency standards. If you think this is a far-fetched example, or you don't like changes in water quality standards, substitute changes in any other media, substitute changes in vapor intrusion action levels, or ecological values, or soil standards. Take your pick as to the media. The intent here being that an NFA was issued, unrestricted use NFA was issued in 05, something changed in 2012, and we have data from 2004 that indicates the site is no longer compliant. My reading of this situation is that the groundwater quality conditions at this site is a REC, either by the 05 or the 13 definition. Remember, the REC determination is done when the Phase 1 was conducted, not when the release occurred. So if there is a violation of standards when the Phase 1 is being conducted, it is a REC, not an HREC. This is a REC condition. It needs to be carried forward through the process, and further action may be necessary. So with that, let's take a minute, and perhaps Liz could share some of the questions we've been getting or comments we've been getting through the system.
Sure, Bob. Can you hear me?
Yes.
Great. I guess let's start with the first question, which I think is a pretty straightforward one. Is it an HREC if the site was closed with institutional controls?
Yes. So, oh no, check that. No, it is not. It is a CREC. It has, if there are institutional controls, if there is a long-term obligation at the site, it is a CREC. It needs to be carried forward through the findings and conclusion section of the Phase 1, and the user has to be made aware of it. The EP has an obligation to alert the user there is an ongoing obligation at the site relative to that issue.
Okay, thank you. The next question we have is if you had a cleanup that was previously done to what was at that time unrestricted approval, but then the state lowered the applicable cleanup standard, does that become a REC? or is it an HREC, or is it a CREC?
It is a REC. As we just discussed in example 2, if there's a violation of regulatory agency standards, it is a REC. Now, some states may have administrative procedures or administrative mechanisms that allow you to revisit the closure of that site and obtain an updated or revised no further action letter, if you will. But for the purposes of the phase 1, you've got a violation of current regulatory standards in effect at the time of the phase 1, that is a REC.
Okay. The next couple questions we have are actually on de minimis.
Yes.
So the first question is, kind of more of almost a comment that, RECs really cannot be client-driven insofar as whether it's a REC or it's de minimis. And they go on further to say that de minimis is regulatory and threat-driven, not driven by the user's feelings, and they'd just like to hear some more discussion on that. And I'm going to follow up with the other question as well, which was about PAHs. Say you find PAHs that are technically above a standard, but the environmental professional feels that they're likely due to general anthropogenic deposition. Would that be the subject of a regulatory action, or would that be de minimis?
I think as I've indicated in the earlier slide, de minimis is a tough, thorny issue to work through, and it has to be done in consultation with the client, depending upon the client's risk tolerance and the ultimate use of the property. The EP, and these are my opinions, the EP does not perform this work in a vacuum. It's performed within the context of a transaction, and the determination of de minimis conditions when no clear regulatory standard has been breached is going to have to be worked through between the parties. Clearly, when there has been a release, when regulatory standards have been exceeded, then the recognition of whether the condition is a REC or not, that decision is made. That's a pretty much simpler determination. With regards to things like PAHs or metals that may be related to natural soil conditions, PAHs from typical atmospheric fallout that exceed regulatory standards. Again, it's going to depend, I think, in the jurisdiction that you're working in. I can speak to New Jersey, where there are procedures to allow for diffuse anthropogenic pollution, what we call DAP, particularly with regards to PAHs, that even though they exceed unrestricted use soil cleanup standards, may not require regulatory action or may not represent a violation per se of a remediation standard. So I'm going to hedge a little bit and say it's going to depend to a certain extent on the jurisdiction in which you're working.
Okay, with that, I want to keep us on track. I have a few more questions that we can ask at the end when we get there, and let you continue on with your presentation.
Thank you. If you talk to subcommittee members who were involved in the preparation of the 05 standard, they will tell you that 05 always included the vapor intrusion pathway, that it was inherent in the REC and hazardous substance definitions, and that it was an essential part of a user's due diligence obligation. I am not so sure I agree that that was true at the time of publication in 05, but the 13 standard has unambiguously removed any doubts and now includes references to vapor intrusion pathways in new migration or migrate definitions and in a revised activity and use limitation definition. In fact, the 13 standard equates VI to the potential for migration of contaminated groundwater and requires the environmental professional to assess it with the same level of diligence. Under the 05 standard, indoor air quality was a non-scope consideration, and EPs and some users relied on that occasionally to exclude consideration of potential VI impacts. That once the material had migrated into a structure, that was an IAQ issue, it was an indoor air issue, therefore was excluded from the phase 1. The 13 standard now clarifies that IAQ is indeed, it remains a non-scope consideration unless the IAQ issue is related to releases of hazardous substances or petroleum products into the environment. So, worker complaints about high humidity, building occupants' complaints about high humidity or CO2 levels or uncomfortable air conditioning temperatures are not covered under the 13, but the presence of benzene fumes in the basement caused by the leaking UST from the gas station next door does need to be evaluated as part of the AAI process. So, while the 13 standard does reference vapor intrusion protocol, ASTM 2610, the EP is not required to implement this and can act on other ways to more definitively evaluate potential VI pathways, including state-specific protocols and procedures if they are available in a specific jurisdiction. Ultimately, regardless of the methodology used to evaluate VI, the intent of the new language in 13 is to ensure that vapor concerns are consistently included as part of phase 1 evaluations. Keeping with the objective of 13 to force or drive a higher, more open level of disclosure, the standard now requires that when the target property or an adjoining property is identified on a regulatory agency report, a review of regulatory agency files be conducted in order to establish the basis for and significance of the filing. Agency file reviews are valuable tools for obtaining a deeper understanding of the issue and how or if it has been resolved. Although file reviews do raise significant concerns between EPs and users with regards to timing and costs. The standard does allow, the 13 standard does allow EPs to use alternate sources of information to obtain equivalent data that would be available in regulatory agency file reviews, such as records from the property owner, local government or non-state agencies, as well as telephone interviews with regulatory officials. However, those sources must be documented and included in the phase 1 report, along with the EP's opinion as to the adequacy or sufficiency of that information. So if the EP is going to be relying on information obtained not through a regulatory agency file review, but through other mechanisms, then the EP has to provide an opinion, essentially an explanation or justification as to why those alternate sources of information are reliable and adequate for the purposes of the phase 1. That leads us that would lead us to the next slide, but it's not coming up. So we'll try to sort through that. Sorry, the next slide isn't working. But the next slide would show that the 13th standard speaks to reasonably ascertainable data as key to the agency file review or the acquisition and evaluation of site information. The standard environmental database report that can be purchased for a few $100s from any number of suppliers qualifies as reasonably ascertainable data. But how many EPs take the trouble to simply Google the site and see what pops up on the web? Ah, there we are. We got it. Similarly, with many newspaper archives now available for free or for a very modest fee, I think you can get on the New York Times searchable database for the entire 200 years of the Times for $6 a day. Searching for the company name or site address might also be classified as reasonably ascertainable data. These data sources typically are not available in commercially purchased database reports. As an example, one site I worked on had a major fire that was not included in either the state or local agency records. Runoff from the fire had picked up some oil that had resulted in a fish kill and a slick on an adjacent stream. A newspaper account that we found just by simply Googling the site name provided details, and indeed the owner, the seller in this case, when shown the clippings, was much more forthcoming about the fire and its effects than he was during the initial site visit and interview. The point being that as technology opens more and more data sources, the user and environmental professional needs to be cautious about taking too narrow a focus as to what is reasonably ascertainable data. It's not just a regulatory agency database report anymore. I think you have to think broader as this information, as more and more information becomes available. With that, I'll touch on briefly user responsibilities, because it's not all about the EP. The 13 standard language emphasizes or reiterates that user responsibilities are required and in practice are essential to AAI compliance. The standard includes more descriptive language on what is considered commonly known, including differences between purchase price and fair market value, which some users or sellers or buyers are often hesitant or reluctant to share with the EP. The 13 standard does clarify that the EP now has an obligation to request this type of information from the user, although the user does not have to provide it. If the requested information is not made available to the EP, including, in my opinion, funding to purchase or otherwise obtain the requested information, then the EP has to list this as a data gap and therefore exclude it from his or her final opinion on the property. So while the EP can ask for it, the user or the seller or the buyer doesn't have to provide it, but the EP is let off the hook as to the consequences of that by identifying this lack of information as a data gap and including that in the findings and conclusion section of the phase one. I do want to point out one common mistake I see in phase ones is that chains of titles, the typical $100 or so report you can buy, typically do not include notice of environmental liens that may be present on the property. Finally, the last slide in the talk, just a quick observation about the format requirements of the phase one report and how they have changed. the 013 standard has gone from a highly detailed 16 major sections, 41 subsections for a Phase 1 report, many of which were repetitive or not applicable, difficult to integrate into the intent of the Phase 1, to a more performance-based 9 major sections. The new report format is down to a modest 13 standard, 13 all-in 13 sections, 9 major sections, no specific subsections, including appendices and other opinions and other administrative items that need to be included. But again, the intent was to simplify the process and allow greater flexibility by the environmental professional in providing the information and reaching his or her conclusions more directly and with greater clarity. With that, I want to thank everyone for their time this afternoon, and let's move to the final Q&A session.
Hi, Bob. Can you hear me again?
Yes, ma'am.
Okay. First question we have is, if a Phase 1 was just done recently, say like this past January, and they did it according to the 05, is it applicable for property transactions today, or should it be redone with 13? And I guess, how does that fit in with EPA all appropriate inquiry?
Right now, the Phase 1 prepared under the 05 standard would qualify. Presumably it's consistent with all the Phase 1 obligations, all the the obligations of the 05 standard. If it is, then yes, it would remain qualified for liability protections under CERCLA. However, going forward, because this was prepared in January and the ASTM standard did come out in November, going forward, I'd recommend that it would be updated to the 13 standard as soon as you could, as soon as possible.
Another question. What is the environmental professional's obligation to review history of ownership by obtaining and reviewing the chain of title for the subject property?
The EP's obligation is to obtain the reasonably obtainable information, reasonably ascertainable information, and evaluate whether prior ownership has identified potential RECs on the property. Chain of title is one of those tools. More full-blown title searches and other real estate instruments are available that provide additional details that supplement the chain of title. But frankly, the chain of title is the minimum and usually not a very useful mechanism to develop a meaningful site history.
Okay. I realize that we are now actually past the time of the webinar, but we certainly have lots of questions still coming in, and we are happy to stay here as long as the questions come in, and we will continue to answer them. So for those of you who have to go, we understand, but for those of you who can stay on, please do. The next question came in. It relates to the question we just had, which is, if you can access reasonably ascertainable data, does that satisfy the regulatory file review requirement? And let's just start with that, and then I'll get to the next question.
Yeah, if the target property or an adjoining property, an abutting property, has not been identified on the regulatory agency database report, then yes, that you have now satisfied the requirement for reasonably ascertainable information. No further evaluation would be necessary. However, if the target property or an adjoining property, an abutting property, was identified as having a problem, then, or an issue, then further research has to be done to satisfy the reasonably ascertainable information requirement.
Thank you. Next question. sometimes records reviews from state agencies, they say they're available, but they aren't available by the time the phase one goes to print. And a lot of times you'll see in a phase one where it says, you know, basically that statement, and that it'll be reviewed later, but often it never is followed up. Where does that fit with the whole all-appropriate inquiry?
Clearly, everyone recognizes that there are timing issues associated with property transactions, and that often there are many data sources that just aren't available at the time, within the time frame that the work has to be performed. The 13 standard, I think, recognizes that, and there is no prohibition for including in the findings or conclusions that say we've got some open data resource or data information or source issues, and that as that information comes up, if it's meaningful, if it's a significant finding, to provide that in a separate follow-up letter.
Okay, thank you. Question about timing. Two questions here, and they're both related to that 180-day window. So if parties involved in a transaction agree to use a phase one that's more than 6 months old, what are the ramifications?
Well, clearly that can be resolved between the two parties. That's a contractual issue, a purchase and sales agreement issue. However, if the buyer is looking for the CERCLA liability relief under the Brownfield Act, that would not be allowed. You would not qualify for that liability relief because you are now not consistent with the ASTM standard. If it's a private transaction and neither party are concerned about liability protection under CERCLA, then that's an agreement the two parties make.
Okay, so that really didn't change between the two, between 05 and 13.
That is correct. It's the 180-day time frame is still in effect.
We had a couple questions about the recommendation section, and people wanted to get your thoughts on that. Typically, the client is sent a draft copy of a phase one, and sometimes they don't like the recommendations and they want them taken out. What do you do in that situation?
Right now, the 13 standard has a recommendations optional section. It's not a requirement, so you don't have to put it in your report. However, in my own practice, I ensure the client, the user, or the buyer, or the seller, who's ever retained me, gets the recommendations, either in a letter or an email or a conference call or some way that gets my concerns about the property in front of the people involved in the deal. It's just too important a component of the phase one. You know, you've been hired as a consultant. You've been hired for your technical expertise and your advice. I feel strongly the client is entitled to that. They may not like the news you're delivering, but as a professional, as an environmental professional, you need to get it to them in some way, shape, or form.
Great, and I think you actually answered really the next question, which is if you do identify, if an environmental professional does identify a wreck, what is their obligation in recommending the next steps to address that? And I think you just answered that. Let's see, the next question. And some of this question, well, let's see, you know, it's kind of state specific, but do states provide CERCLA-like brownfield prospective purchaser protection? For example, you know, if you find a wreck and you buy the property, are you liable for those pre-existing conditions?
I think generally speaking, if you've got an AAI compliant phase one report, you would be and it's kind of a legal question, and I'm not an attorney, but I think generally, from my experience, has been that an AAI compliant phase 1 would indeed provide a strong basis for defense from CERCLA liability at a state level. That most states, with some exceptions, as I'd mentioned earlier in the talk, including here in New Jersey, would indeed recognize that the buyer was proceeding in good faith, that they did acquire the property, it was acquisition without knowledge, they met the intent and the basis for liability protections under CERCLA, and that you'd have a very good defense in that regard.
I think at this time we have a couple questions for Patricia Obermeyer, and then we'll come back to you, Bob. So I'm going to ask our host, Sean Groom, to unmute Patricia. And so, Patricia, these questions go out to you. And the first is, can you just give us an update on where EPA is with the agency conversion to the 1527-13, and an update on the rule and timing of that. So hopefully, Patricia, you can hear us and you can respond. If not, you could chat back to us and we can provide those answers back to the participants.
I can hear everybody else. Can you hear me?
Hi, Patricia. Can you hear us?
I can hear you. Can you hear me?
Yes, great.
Okay. So EPA is currently working towards one additional rule under the AAI, and that is, as Bob said earlier, that we will propose a rule probably this spring to remove the 05 reference in the AAI rule, so that the idea being that we want folks to use the latest industry standards. EPA really supports the update to the 1527 standard, and so we highly recommend that people transition to the 13 version of the standard, and we are going to reflect that in the upcoming proposed rule by removing the 05 reference so that there's no confusion with that.
And we did have a couple more comments or questions for you. One is, I guess this past summer, the National Brownfield Association Michigan chapter was recommending that people still use the 05 because at that time EPA had not yet adopted the 13 standards. So has that changed?
Yes, EPA recognized the 13 standard in a rulemaking that was finalized and put in the Federal Register on December 30th of 2013. So ASTM made the standard available in November, but we did not recognize it officially until the end of December. So I'm not hopefully we'll clear that out, and the NBA won't recommend the 05 standard.
Oh, Patricia, we got a comment that the sound quality wasn't very good on your first response, which was about the timing. Can you just say that again?
Yes, the ASTM made the new revised ASTM standard available in November, but EPA's rulemaking recognizing the 13 standard wasn't published until December 30th. So that was probably the reason for the NBA in November to say not to use the 13 standard, but the 13 standard is now recognized by EPA.
And are you expecting comments still?
Not on that rulemaking. That was a final rulemaking, and part of that rulemaking was a response to comments document for those people who responded on the proposed rule that was published last August. Now this spring, when we put out the rulemaking to remove the 05 version of the standard, that will be a proposed rulemaking, and we will accept comment on that.
Okay, I think that is really going to help our audience. And then the other things I think are almost more comments to EPA, so I'll just kind of, try and summarize them a little bit. But you know, there's a lot of chatter going on about why the definition for environmental professional was left in place, and it relies so heavily on professional judgment. A lot of people feel like this is allowing companies to become phase one mills, and they're really, you know, wanting to see a change to that. So I think that's just more of a comment to you. If you have any comments back, that's, you know, we'd love to hear that.
The only thing that I would say is back in 2005, when we put out the proposed and then final rule on all appropriate inquiry, we accepted comments. We solicited and accepted a lot of comments and considered those comments on the definition of environmental professional that was proposed. And for every person who doesn't like the definition, there's about 1,600 that do like it. So I understand, you know, that people could have their opinion about who meets that definition, but users just have to be very smart with whom they hire. If you don't want someone that is minimally qualified, you're shopping for your environmental professional. You have every right to get a more experienced and more highly qualified person. So I don't think the definition should keep people from getting better service. It's a minimum, it's a floor. I think it's working. I think opening up for comment again is just going to get us the same flow of very, very diverse comments.
Okay, thank you, Patricia. I think so far those are the only questions I think that we had specifically for EPA. So I'm going to ask Bob Blauvelt to come back on, because we still had some more questions for Bob. And I am going to start with, I guess some people are looking for some clarification, because I know, Bob, when you answered that one question about CERCLA liability, you were really talking about federal CERCLA liability, and our audience wanted to understand, do states kind of have a different take on it? Like, for instance, I think I can comment on New Jersey, which is under like the Spill Act in New Jersey. If you purchased a property knowing that it had contamination that you found through your phase one, you did a rec, you now become liable under that to, you know, an affirmative obligation to remediate that. And I think kind of the question goes to that, and, you know, are you aware of other states that are similar? I think that's where we were headed with that. So, Bob?
Yeah, it's a difficult question to answer broadly, and that's kind of why I kept my answer a little vague initially, is that the individual states may indeed have other things you need to do in addition to a phase one. It's really going to go to the requirements of any individual state. And that's why, to piggyback on Patricia's answer, is that you need to hire a competent professional who's experienced and knowledgeable about what those other state requirements may be. I can say, in general, most state regulatory agencies, if you've got an AAI compliant phase one, if you've got a phase one that meets this ASTM 152713 standard, then you will have a very adequate shield or a very adequate defense if an enforcement action is initiated. If you need to do other things than that, it's really up to the environmental professional the buyer or seller retains to alert you to those other requirements.
Okay, thank you. So let's see what else we have here. Some of these get a little more site specific, but let me start with this. In some instances, a city might have a citywide, like, groundwater restriction, institutional control. Mm-hmm. Is that considered a CREC, even if it's not specific just to the subject site?
It would be considered a CREC if the owner of the property, of the specific property, had an obligation to do something. In other words, if there was a restriction on a well he was using for air conditioning or in some sort of process, or if there was a restriction not to install a drinking water well, then that would be considered a CREC and would get carried through the process.
Okay.
Now, there may not be, just to finish that, there may not be any recommendation associated with that in the Phase 1 report, but it would qualify as a CREC.
Another question, changing topics a little bit here. Should tribal regulatory water quality standards be used in the REC determination on tribal lands, or should federal standards be used?
And I run into this question in certain states when there are, for example, a local municipality or county standards. The EP has an obligation to look at both federal and other standards and determine whether the conditions at the site violate any current regulatory agency standards, whether they be federal, state, local, tribal, whoever the competent authority is that's managing that property. You compare, you make your evaluation based on those standards that are in effect.
Okay. Next question. We've got a couple questions about dry cleaners. And first question is, what about like a historic dry cleaner or a print shop or something like that that has no documented releases?
Dry cleaners, similar to gas stations, there are, in my experience, especially older dry cleaners, there are two types: those of where contamination has been found and those where you haven't looked yet. So I think it is incumbent upon the EP to alert the user of the Phase 1 that dry cleaners have long and well-documented histories of environmental problems. And I think if that were my report, there'd be a recommendation to do some intrusive sampling, to do some further investigation.
Would you call it a REC?
Yes.
Okay.
Even though a regulatory agency standard hasn't been exceeded, there is a high likelihood of a potential release to the environment.
Okay. Next question is about VI, vapor intrusion. Would vapor intrusion concerns related to a hazardous substance being used as part of a business's legal operation, even though there's no uncontrolled release that is known, would that be an issue that you would note as a REC?
So to clarify that, if you're at a industrial facility and they're using TCE in one of their processes, but there's been no release of TCE to the environment, is that a REC? And the answer would be no. That's an indoor air quality issue. That is a non-scope consideration. Again, I would probably work that into the report somewhere so that the user knows that chlorine, highly regulated and well-known environmental contaminant, is being used in the process.
And that actually leads right into another question, which is, can you comment on non-ASTM scope items and how you incorporate them into a Phase 1 if it's a user requirement?
Yeah, again, there's a protocol described in the standard that describes how to do that. Essentially, you work those into the text, into the now 13 subsections. You identify them clearly as non-scope considerations, and address them in accordance with your client's or the user's preferred format. And whether that's radon or wetlands or indoor air quality or what other lead in drinking water, whatever those concerns may be, you incorporate them into the Phase 1 report.
Okay. Question about does ASTM or any other organization make available a consensus option on implementation of a standard? Or what they're really getting at is, what is the definition of de minimis? How do you really determine that? Has somebody made that? Or also they asked about VI considerations as well, vapor intrusion.
Not sure I understand the question. Sorry, Liz.
Yeah, I'm having trouble with it too, but I guess what they're looking for is, has ASTM just made a very clear definition of what is de minimis?
Yeah, the de minimis is defined, but a number of the key terms in it aren't, if you know what I mean. So it's really up to the environmental professional to use their judgment, which is not a bad thing. This is again why you've retained an EP to provide that perspective. The de minimis one, as I indicated in the talk, is a pretty thorny set of issues that you need to work through with your client.
Okay. I think just a couple more questions here. Is there a benefit to the property owner, in this case the user, to redo a phase one that was done in 2010 if the conditions have not changed? And I guess this is a person perhaps it looks like that's getting ready to sell their property. So it looks like a buyer would probably be doing their own phase one.
Yeah, yes, I understand the question. I would suggest that should be worked out between the parties and the people that are financing the transaction. Right now, with the 2010 phase one, it would not, the transaction or the buyer would not qualify for CERCLA liability protection. If that's important to the buyer, then they wouldn't need to redo the phase one regardless of whether conditions have changed or not.
Okay. And I think we're down to the last question, and that's unless any more questions come in. Can an environmental professional use the likely presence of a contaminant as a reason to call something a historic site operations wreck? I'm not sure I completely understand that question. But.
Yeah, an HREC, an historic recognized environmental condition, is one that is an issue that's been identified at the site and achieved unrestricted use regulatory agency closure. No further obligation. We came, we saw, we conquered. The release has been cleaned up. We've got a piece of paper from somebody saying we are done. Anything else other than that gets classified as either a wreck or a CREC.
Okay. I think, we have one more question that just came in. Let's see. What about a situation where a state agency has filed a closure letter for a past UST petroleum release, and then the review of the agency file identified that they didn't do a vapor intrusion investigation, and that particular state has indicated they're not planning on reopening closed cases due to vapor issues? Is the lack of a soil vapor investigation considered a REC or an HREC?
Depending upon the extent of the impacts, the location of the building, let's assume worst case that it's immediately adjacent or even on your property, then if it were my practice, I would consider that a REC. That's a migration pathway that has not been evaluated, that needs to be evaluated, and I would classify that as a REC and recommend further action.
Okay. I guess somebody's asking about ICs. I believe they mean institutional controls. Where do you find out about those?
Institutional controls typically are associated with the title or the land use, the land ownership records of a property. Some state agencies have databases where they're searchable, but they are most reliably found in title searches and other real estate related documents. That's why it's so important for the EP to ask for that information from the user, from their client, because that's where those types of instruments are recorded.
Okay. I have a couple more coming in. Somebody in the audience is saying they've started to find that there are inactive sites when they go to do their regulatory file review. That the agency that they've gone to has purged the files are no longer available. So they're wondering what to do for a site when that happens. And I guess in this case, I think they even said it might even be the adjoining site. If it's a target property or the adjoining site, how do you handle that issue?
Yeah, and if the regulatory agency, for whatever reason, no longer has the information available, then that qualifies as not reasonably ascertainable. The EP should note that in the Phase 1 report. And again, depending upon what their professional judgment indicates as to how serious a concern may be present on either the site or the adjoining site, depending on the issue, may want to identify that as a rec and recommend further action.
And we got a little bit of a response to your inquiry for people to send in information. This also brings on a little bit of a question. It's a little long, but bear with me here. So in Virginia, there is not a standard for petroleum constituents with regard to leaking underground storage tank releases. However, the Virginia DEQ does issue the no further action closure letters without indicating the property can be restricted or unrestricted. So as far as reviewing those regulatory files, are they required to compare the concentrations found in groundwater to the risk-based tables that they have in the voluntary remediation program as part of their Phase 1 ESA conclusions and findings?
Wow. Well, we all know Virginia is a wild and lawless place with regards to environmental regulations. I think I understand the question as that the type of no further action letter or regulatory closure letter isn't specific as to whether it's a restricted use or an unrestricted use.
Mm-hmm.
And how do you make that determination then as to whether this is a REC or a CREC or an HREC? I think you would have to go and make those comparisons because at the end of the day, depending upon the use of the property, the user is going to rely on your determination in that Phase 1 report. So I think you've got to alert the user that that situation is in play and make the evaluation as to whether or not the reuse of the property is appropriate for residential or some other commercial activity.
Okay. Thank you, Bob. I think that I have gotten to all of the questions that came in. If there's anyone out there whose question I missed, I apologize. If you have a moment, please send it back to us. We'll either answer it now or we can get back to you separately after this. So with that, let me do the wrap up and say thank you all so much for being a part of this webinar. We had such a fantastic question and answer session. We're really pleased with your participation. We hope that you learned a lot today. If you have ideas for future webinars, let us know what those are. Again, if you would like to avail yourself of the free technical assistance to brownfield services from NJIT tab, we are here for you. And we will be posting this webinar on our website. It will take us a little bit of time to get it up there, but it will be there at njit.edu/tab. We will also post the slides themselves. And I'd like to thank very much Bob Blauvelt for all his hard work in putting this together, and thanks Tricia Overmeyer for being on the call to answer the questions from ETA. And with that, this concludes our webinar. Thank you.